Hi everybody. Hi everybody. We are moving on to Module 3, and this week our concentration is torts, would be actually our torts and criminal law. So we will talk about torts together, but there are two different types of torts. As you can see from your reading, we have intentional torts. We also have negligence. So we'll talk about both of those maybe a little bit separately, but they all fall together under that heading of torts. And the second part in Chapter 9, we talk about criminal law. Wish we could spend more time on this. It's really kind of an interesting subject matter. Really, when you think about corporate crime, those types of crimes are white-collar in nature, and it's a very hot issue lately, and it's something that has the impact or the effect of injuring so many different people, thousands if not millions of people all at one time, which is something that's a little bit unlike regular street crime. So it's rather interesting. It's rather complex in terms of the litigation and prosecution of white-collar criminals, so wish we had a little more time to talk about that. But let's get started. Let's talk about the first chapter, and that chapter deals with intentional torts. First, let me tell you what a tort is. A tort is considered to be a civil wrong. The person who commits that civil wrong is called the tortfeasor. The tortfeasor, in terms of intentional torts, has to show or demonstrate some sort of intent. That's why they call them intentional torts. They're not easy to prove, but there are times when there is sufficient evidence to show that a person acted willfully, deliberately, and with the intention of doing an act which is considered to be a civil wrong. The impact of civil versus criminal is that civil will allow other people to sue you for money damages, and we'll talk about the damages part of a tort action in just a second, but that is really the big difference. In criminal law, we look at incarceration or fines, or probably a combination of the two, if a person commits a crime. A crime is not a civil wrong. A crime is a criminal wrong or redress against something that society has said is not to be done. So when you commit a crime, you are actually committing a wrong against the state, for lack of a better way of saying that. When you commit a tort, you are committing a wrong or a violation against a private person, and in order to get redress for that, private parties have to sue for violation of torts, but in criminal law, it's the state that brings the action and sues on behalf of the victim. That's a big difference. The burden of proof in civil versus criminal is also another big distinction. In civil law, the burden of proof is by a preponderance of the evidence, whereas in criminal law, the burden of proof is beyond a reasonable doubt. So as you watch TV and as you proceed through your life, you will see in the media oftentimes a high-profile case, Casey Anthony, the Zimmerman trial down in Florida, even way back to the O.J. Simpson case when I was in law school. But as a practical matter, lots of times civil lawyers will wait until the criminal action is done in order to bring their civil case for a violation of one of the torts that we have. The reason for that is because the burden of proof in the criminal system is so much higher than in the civil system. If a person's convicted of a crime, that automatically establishes civil liability. So you take that from this course and understand that it makes you a little bit more of an educated citizen in our country, understanding how these complexities in litigation, civil and criminal, all overlap with one another. So the burden of proof, a criminal beyond a reasonable doubt, if I were to look at that on a timeline, that would be somewhere around 100%. It's pretty close to 100% certain or positive. But in the civil system, which torts falls under, beyond by a preponderance of the evidence is a little more than half, so say like 55%. That's a big difference. So you can be, it's more likely than not that a person committed a wrong, but you have to be almost virtually positive that somebody committed a crime. And the reason is the stakes are a lot higher. It's one thing to have to fork over a whole bunch of money, but it's quite another if someone's taken away your life or your liberty. And the reason for the higher burden is that the outcome or the stakes are much higher in criminal law. So intentional torts, you have to show that intent. We have many different ones that we look at. We talk about defamation, which is one. You cannot slander or libel another person. And it requires proof, though, that the other person said these things knowing that they were wrong, or knowing that they were not true, with the intention of harming somebody else's reputation. So as you look through there, a big difference between the two that you should pick up on, libel is the written word and slander is the spoken word. Slander starts with S and so does spoken, and that's how I always remember the difference between libel and slander. You don't have to get into huge amounts of detail. I did not ask you tons of questions about defamation. It seems to be a fairly involved subject matter area of the law, but I'd like you to know what it is, what things fall under there. We have many different intentional torts. You can have false pretenses, you can have malicious prosecution, you can have all types of other intentional torts that you looked at in your reading. So the thing to pick out on them, understand what they are, find them if you need to look them up, and just look for that element of intent. Anytime you have to prove intent, like with fraud, then you really have to, the person who's bringing that cause of action has a really hard job. You know, how do you prove that? It's one thing to, if you know it in your heart, but another thing to bring forth enough evidence in court to prove to the court that this person actually engaged in intentional behavior. Intentional behavior is punished more severely than simply negligent behavior, which is the other type of tort that we'll talk about in a moment. So usually the you know, if there's an intentional tort that is committed, for example, the court may award punitive damages in jurisdictions that allow punitive damages. Washington State is not one of those jurisdictions that allows punitive damages, but as a way to punish someone for bad behavior like that, intentional and willful conduct that injures or harms somebody else, is really, it's tough. So notice how one act can constitute both a crime and a tort. You know, the O.J. Simpson case that I referred to a few minutes ago, he was charged with the crime of murder. And the civil equivalent of murder is wrongful death. So, sorry, my hair's falling on my face here. Notice how that one act can constitute both a violation of our civil laws as well as our criminal laws. And that's perfectly fine. It is not a violation of double jeopardy to sue someone civilly as well as have the state sue them or prosecute them criminally. Double jeopardy only applies to criminal prosecutions. You cannot retry the person for the same crime twice once there's been jeopardy is attached, which means that you've reached a critical stage in the proceeding, or it's already gone all the way through trial to a conviction or an acquittal. All right, so let's talk about negligence. This is really the much bigger area of tort law. Negligence is something that we've all committed negligence at one point in time in our lives. You can't be human and not make a mistake. And that's simply what negligence means, is that you are making a mistake, but at a time where you owed somebody else a responsibility to act a little bit better than you did. Oftentimes people who are in car accidents, somebody gets injured, maybe you were just changing the channel, the sun got in your eyes, something happened, and you bumped into the car in front of you. That's a rear-end collision. You would be sued, if at all, for the tort of negligence. Negligence has 4 requirements in order to establish it. The first is that you owed a duty to the other person. In our car accident example, that duty would be to use reasonable care and caution while driving your motor vehicle. That duty has to then be breached in order to reach the second element in a negligence action. If you don't look at the roadway and you're looking down at your cell phone, if you're looking at the radio, you're looking out the other side window, you're not having proper lookout on the roadways, you are breaching your duty of care. Then the third element is that causation aspect. It is 2 parts. I'm not going to be a nitpicker and have you make sure you understand between actual and proximate causation, but causation comes in 2 forms. But just know that the injury, which is the 4th element in a negligence action, has to have been caused by the breach of the duty owed by the defendant. So duty owed, duty breached, causation, and damages, those are your 4 elements in a negligence action. If you look at negligence, you will see that there are a couple of specific defenses that are available. So if someone sues you for negligence, you have a couple of options. You can say something called assumption of the risk, which means suppose somebody came into your yard and they saw that you had a giant sinkhole in your backyard and they were really intrigued by it. and they went over to it even though you had warning signs and tape all around it, and they still fell in and they got hurt. If they then sue you for negligence, did you have a duty? Yes, you did. You had a duty to keep even trespassers safe on your property. Did you breach that duty? Questionable, right? And was your breach of that duty the cause of this person's injuries? If they can establish negligence, you can still bring up the defense of assumption of the risk. This plaintiff assumed a known danger. They saw a giant sinkhole and still went over to it and fell in. As a result of that, the assumption of the risk doctrine can be used as a defense in such an action. A more likely defense in many tort cases involving negligence is comparative or contributory negligence. And every state has its own version of this. Some have pure modified. Contributory negligence means that if somebody has contributed even 1%, if the plaintiff has contributed even 1% for the accident, then that plaintiff is barred. And that's a pretty harsh doctrine, to have. Some states still retain that. Some have modified that to say if the plaintiff has caused more than 50% of the accident, then the plaintiff is barred from recovering, and that would be a modified version of contributory negligence. And then there's comparative negligence, which means that the plaintiff's damage award is discounted by however much that plaintiff was negligent himself or herself. So that means that if the plaintiff is 99% at fault, then the damage award is reduced by 99%. But that finding of 1% negligence can have some impact because it can actually make the other party liable for attorney's fees. So there are considerations to be had on all sides there. And I think that's about it for purposes of that. The other thing I just wanted to mention are your damages. We have many different types of damages in tort law. We can have compensatory damages, which are your basic types of damages for your out-of-pocket losses. This could be your doctor's bills, property damage to a vehicle, for example. These are the out-of-pocket direct result of this accident. The next type you might have are consequential or incidental damages, and these are the type of damages where they flow as a result of this accident or one of the injuries that you received. So perhaps you had to have retraining or something like that. You couldn't go back to your regular job. Something that is a little bit more attenuated but still has a logical connection to whatever the injury was that you received. The last type of damages that we have, or there are a couple others. One is nominal, and that's like really just giving $1 to recognize that there was responsibility, but there's no real damage, that somebody suffered. Consequential, which you really don't have to, think about too much, but we talk about consequential a little bit more in contract law when we talk about lost profits and making sure that your profits are not too remote and speculative. That's about it for the material from Module 3, and we will get started with Module 4 in just a few minutes. Thank you.